Well, thank you very much, Dean, for that wonderful introduction. It is my great pleasure tonight to introduce my colleague, Mark DeGirolami. Mark joined the faculty a few years ago, and as Dean Simon says, is already one of the most important people on the faculty. And for those of you who are not in legal academics, you may not know how unusual it is for your first book to be picked up by Harvard University Press, which is what happened with Mark. And that really is a great achievement, if I may say how proud we are of you for doing this, Mark. So let me bring you up. So the game plan for tonight is we're going to talk a little bit about Mark's book in a kind of dialogue to facilitate things. And then we'll tell you a little bit about the Center for Law and Religion, and then we'll let you get back to socializing. Okay, so this is Mark. You've heard a lot about him. So, Mark's book is titled The Tragedy of Religious Freedom, and I think it's fair to say that Mark's basic take on law and religion in the United States is that it has gone somewhat wrong, principally because it focuses on only one value at a time, on the value of equality, or the value of freedom, or the value of diversity, or what have you. And Mark takes aim, therefore, at the corpus of law and religion in the United States and tries to come up with a wiser understanding that focuses on many different values. So let me begin, Mark, by asking about the title. The title is The Tragedy of Religious Freedom. And so do you think religious freedom is a sad thing? Why do you call it the tragedy of religious freedom?
Okay, so that's great. Thank you, Mark. And before getting to that, it wouldn't be right for me not to acknowledge how grateful I am to my friend Mark, to the dean who's been so generous with me, to Maureen and Claire for putting on this event. I see around the room some of my old constitutional law students. I'm so grateful that they're here. I feel like I'm giving it like an Oscar acceptance speech.
Don't get to thank the Academy.
Fellows, right, the fellows that were part of the center, my research assistants who were part of this book, go and introduce yourselves to them, Aura and Josefa, and there's Jordan Hummel over there, other colleagues who are here. I'm really very touched and grateful that you came, and of course my family, my wife there in the back, even came to this event, even though I know how boring she thinks this book is. So the title. The title is, as Mark says, The Tragedy of Religious Freedom, and I use the terms tragedy and comedy in the book in a somewhat stylized way. There are connections, of course. Tragedy and comedy are ancient terms. There are philosophical and literary connections, associations that those terms evoke, and I draw on some of those in the book, but primarily the terms mean, as Mark was alluding to, a tragic approach. Let's just start with a comic approach, since it's the approach that I criticize in the book. A comic approach, and it doesn't really have to be just about religious liberty. It could be about law more generally. A comic approach is an approach that says, okay, when we've got a problem, when we've got a conflict in court, what we need to do is we need to reduce the conflict, boil it down to a single value. And usually that value in the religious liberty context is the value of equality. It could be other values, but we need to look at the conflict through a particular lens, a lens of a value. So it's almost like you're coming down on top of the conflict and you're saying, I've got this value in mind, equality, let's say, and unless you can explain to me why the conflicts within the legal clash implicate a certain value, then it's not going to be the kind of conflict that we care about. So why do people do this? Why are conflicts analyzed in this kind of way? And we can give some concrete examples to flesh this out. But I think it makes the conflicts easier to decide when they are reduced to a single value. It makes them more predictable. The decision becomes, maybe you can tell more easily what the outcome is going to be. Those, I think, are the primary reasons, those two reasons. So what's wrong with this? Well, I say the reason that this is wrong is that oftentimes these conflicts cannot be reduced to a single value, and doing so flattens them out in ways that misconstrue them. So for example, if you've got a conflict like a Native American tribe objects to the government's plan to build a road right through lands that it deems sacred, unless, from the comic approach, that conflict can be analyzed and understood through the value of equality, it's not going to be something that we care about. Native American tribe is going to lose in that conflict. My approach, a tragic approach, resists the kind of boiling down, the reduction that happens when conflicts are viewed from through this comic lens, and says, look, there are too many different kinds of concerns in play to analyze these conflicts in this way, and we do violence. We misunderstand what's really at issue when these kinds of conflicts are analyzed in this way, and we ought to do something else. We ought not to analyze these conflicts through a comic lens. And what we need to do is perhaps going to be the subject of the next question, but it isn't analyzing conflicts from the top down. It isn't superimposing a value from the outside on top of the conflicts. It's looking at some of the history that surrounds a particular legal fight and trying to balance various kinds of competing considerations. So that's I think, as best I can say.
Okay, so that's generally. So maybe to give an example, why don't you talk about an opinion that you would find comic,
okay,
or not good?
Good. So, and for those that don't know, especially my constitutional law students, because we didn't cover the First Amendment in common law, there are within the First Amendment 2 religion clauses. There's an establishment clause and there's a free exercise clause. The First Amendment begins, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So right there you can see you've got a clause of the First Amendment protecting free exercise of religion and a clause prohibiting laws respecting establishments of religion. So the case that I think most closely resembles or exemplifies a comic approach in the free exercise context is in fact the most important free exercise clause case of the last 30 years, and it's called Employment Division versus Smith. And in Employment Division versus Smith, the conflict was this. You had a Native American part of whose religious rituals involved the taking, the ingestion of peyote. And so this Native American ended up being dismissed from his work for the reason that he had ingested peyote, and the Native American sought unemployment compensation benefits, and these benefits were denied him because the reason that he had been fired was for the ingestion of peyote. So the Native American sued. He sued under the free exercise clause, and he said, ingesting peyote is part of my free exercise rights. You can't punish me, you can't deny me certain benefits on the grounds that I have exercised my religion in this way. Okay, so what happens in the case? Well, the case is notable. It's a decision by Justice Scalia, and the case is important for a number of reasons. Number one, Smith rejects what had been the previous free exercise doctrine, which had been more along the lines of what I'm talking about, a kind of balancing approach. And my common law students do know about Employment Division versus Smith, because it's one of the only cases that I managed to sneak a little bit of religion in there. But Smith rejected the previous doctrine of free exercise, which was a kind of balancing approach, where you look at the interests of the state on the one hand, you look at the interests of the religious believer, and you try to adopt a kind of multi-factor approach where you decide, given the particular context, which party should win. Smith said, no, 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 no. What we need is we analyze this dispute through the lens of neutrality. That is, Justice Scalia came up with this rule, and the rule says a neutral law, which applies generally, will never violate the free exercise clause, no matter how burdensome it is to the religious believer, and no matter how unimportant the interest of the government might be. If it applies generally, if the government is not discriminating overtly, intentionally, against a religious claimant, then it's just not the kind of dispute that the Constitution is meant to protect. So why is this a comic approach? Well, because it's an approach in which you take an abstract value, the value of neutrality or non-discrimination, and you superimpose it on the free exercise clause, and you say, I don't care what is going on, unless you can explain to me why neutrality as an abstract matter is violated, or non-discrimination as an abstract matter is violated, I don't care. It's not the kind of dispute that I care about. So that's, on the comic side, I disagree with that kind of approach. I disagree with that kind of a doctrine that adopts that kind of approach, because I prefer, and I guess I'll give, you only asked me about the comic side, but I'll give you the tragic side now. So an approach that takes a more tragic view of these kinds of issues is, I think it's the most recent religious liberty case decided by the Supreme Court. And it's a case called Hosanna Tabor versus, it's an EOC, the EOC versus Hosanna Tabor Evangelical Lutheran Church. I think I've got them all. And the case involves something somewhat technical concerning what was called the ministerial exception. And the ministerial exception is this. It's a special doctrine that permits a religious institution to decide who counts as a minister for its purposes, and it permits that institution to hire and fire people that count as ministers without being subject to the anti-discrimination laws. So, for example, if a church doesn't like the particular music that its organist is playing, right? It has liturgical differences between the organist and the church. It can decide this person counts as a minister, and we can fire this person for whatever reason. We're not going to be subject to non-discrimination laws. So the response is, well, what happens if you're firing the person because the person's black? Or because the person is a woman and you wanted a man organist, right? Reasons which traditionally have been forbidden, are forbidden by anti-discrimination laws. Ministerial exception rule says, that's not the kind of issue that courts are going to get involved in, because there's an exception. There's a ministerial exception to the anti-discrimination rules. So what did the court do in one of these kinds of cases involving a teacher in Hosanna Tabor? Well, what it said was, first of all, we have to decide whether there is a ministerial exception at all. And in order to do that, we have to look to the history of religious freedom, what religious freedom historically was meant to protect. And one of the things historically that both the religion clauses and more generally the American tradition of religious liberty is meant to protect is the autonomy of churches to decide who gets to be a minister, right? Who gets to be a minister, what kind of minister they want. So there is this tradition, this historical tradition of separation, right? Separation between church and state means at least a kind of autonomy of these two realms, where if you're a church, you get to decide who gets to be within some kind of hierarchy or some kind of position of importance within the church. That's number one, historical approach. Number two, we don't say like a comic approach would say, okay, and now I'm going to take the value of equality or neutrality and superimpose it on this particular conflict. What we do instead is we ask a number of questions. So we say, what are the official doctrines of the church? Does it allow discrimination in certain contexts, or does it not allow discrimination in certain contexts? Is it acting consistently with its own stated rules? What kind of relief is the plaintiff seeking in this case? Are they seeking reinstatement? Are they actually seeking to be put back in the same position to force the church to accept what it could otherwise not accept? Or are they looking for damages? How much money are they looking for? Are they looking for an amount of money that the church could pay, in theory? Or are they looking for an amount of money that would bankrupt the church? What kind of understanding does the church have of the particular position? I mean, if it's somebody who's an administrative assistant, that's going to be different than somebody who teaches Sunday school. So my approach adopts this kind of highly particularized set of inquiries, as opposed to an approach that would, again, from the top down, superimpose a value. So you could say my approach is from the ground up. It's a bottom-up approach, and that's the primary critique that I bring to bear in the book.
Great, well, thank you so much. I'm sure there are some questions about this, and we'll take a couple, but we thought it would be a good opportunity also tonight just to tell you a little bit about the Center for Law and Religion, because Mark's work we take credit for in part. It is one of the activities of the Center for Law and Religion, but we have some others too. So let me just briefly tell you about this. There are, on all the tables, there are some brochures, a couple of different ones. Please feel free to take them with you. I think they're nice. So let me tell you about the center. The center was founded in 2010, so now 3 years ago, and it has three basic missions: to examine the role of law and the relationship between religion and the state, to explore the concept of law in different religious traditions, and to promote St. John's Vincentian mission by encouraging an open dialogue on law and religion in the local, national, and international communities. And we do that in a number of ways. I will just tell you four. And if you want more information, we're happy to tell you about it, and we can talk about it during the break. But four things I want to tell you that we do, four major programs. Number one is we have a colloquium on law and religion, which brings outside scholars and judges to St. John's to teach a seminar to our students. They come and they present draft papers, just like an academic seminar. The students write short response papers, and then the students actually engage in a dialogue with the speakers. Last year we had Justice Scalia as one of the speakers. There's a picture of him with our students in the brochure. This year we're going to be doing the colloquium in conjunction with Villanova Law School. We're going to set up a high-tech virtual classroom with a high-tech video device so that the schools can communicate and students in both places will be able to participate. And I think it's going to be a great thing for our students and also for the Villanova students, and I encourage you to ask about that. The second major program is academic conferences. We've been doing a series of conferences on comparative law and religion at our foreign campuses. You may know St. John's has a campus in Paris, and St. John's has a campus in Rome. Our first conference was in 2010 at the Paris campus. It was on laïcité, which is the French version of separation of church and state. We compared the French version and the American version with scholars from France and actually other countries too, other European countries, and the US. That was our first one. Our second international conference was at the Rome campus last year. It was on state-sponsored religious displays. We had scholars and judges, including Judge O'Scanlan from the Ninth Circuit, who is a St. John's grad, come and talk about the different approaches in the United States and Europe with respect to public religious displays. That's going to be published in the Journal of Catholic Legal Studies this year. The Paris conference was also published in the Journal of Catholic Legal Studies. I should have said that. Next year in Rome, we're doing another conference. The conference in Rome is going to be on religious freedom in international human rights law. And we're going to look at things like the persecution of Christian minorities in the Middle East. We're going to talk about the UN institutions. We're going to talk about the geopolitics of religious freedom. Again, we will be convening scholars and judges and policymakers from the US and Europe, and we'll publish, I'm not sure where we're going to publish those papers, but we will find some place for them. Okay, so those are our conferences. The third thing I want to tell you about is our blog, Center for Law and Religion Forum. We're very proud of this. It is a regularly updated website with law and religion news and scholarship and commentary from around the country. We have now, I think we have about 180,000 views. We get about 250 to 300 a day. Some days we get more. If we're particularly provocative, we get picked up, and then we get thousands. It just depends. But I really encourage you to look at it because I think genuinely it is a great site and it's a lot of fun. It's been a lot of fun to do. And I think you'll get something out of it. Number 4 is our Student Fellows Program. There's actually another brochure on the table about that. Every year we select from among the St. John's student body 5 students to work as student fellows in the center. And their role is principally to help with the blog, with CLR Forum. They are primarily responsible for the scholarship roundup feature, which means that each of them, once a day, will post 2 or 3 new books on law and religion. And this has been wildly popular among academics, principally because academics like to read about themselves, and so it's great to see their books up on the web. And we have some of our former fellows here. Dylan Sherwood is here, Josefa Haber's here, Jordan Hummel. They all were fellows before and did a fantastic job for us. The new fellows are actually in the brochure. This has really been a great experience for the students, and I have to say it's been a great experience for me and for Mark as well. So those are just some of the things that we do. I really hope I can encourage your participation in this and your enthusiasm for this. It has been a wonderful experience. I want to thank Dean Simons for supporting it as much as he has. If you would like to participate in any of these programs or learn more about it, please ask me or ask Mark. We'd be more than happy to talk to you about it. Okay, so thank you. That's just the little. Do you want to say anything about the center, Mark?
No, you said it all. But buy the book if you want. It's over here. Columbus Day is coming up. In case there's an Italian explorer on your wish list that might want a book, you can buy one for him over there. And do get involved in the center. I think you'll really follow us, look at our blog, support us in whatever we could use your support. We want your support. And thank you very much again for coming to this. It's really a treat for me. I'll never forget.